morning. Please be seated. Now we have Ms. Belling. Can you see and hear us all?
I can. I hope you can see and hear me.
We can, thank you. And could you state your full name for the record?
My name is Janine Mary Belling.
And I understand that you wish to affirm rather than...
Yes, that's correct. Yep.
I'll read out the words of the affirmation, and if you could repeat them as I pause. I, Janine Belling.
I, Janine Belling.
Sincerely declare and affirm.
Sincerely declare and affirm.
That the evidence I give to this commission.
That the evidence I give to this commission.
Shall be the truth, the whole truth, and nothing but the truth.
Shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. Ms. Seawood.
Thank you. Ms. Belling, you previously worked as the Director of Licensing and Chief Casino Officer at the Department of Racing, Liquor and Gaming.
Yes, I did.
And you received a witness summons to appear at this Royal Commission.
I did.
And you've prepared a witness statement in response to that summons. If the witness could please be shown DLG.0001.0005.0001. _R. Has that come up on your screen?
It has, yes.
Thank you. And is that a document that has the date of 20 May 2021?
Yes, it does.
And if I could get it scroll through to page 19. Do you have a hard copy with you as well?
I do, yes.
And goes through to paragraph 95 on that page. And if we go over to page 20, goes to paragraph 96, and you signed it, although this version on the screen has that redacted.
Yes, that's correct.
And is this a copy of the statement you prepared for the purposes of this Royal Commission?
Yes, it is.
And is the content of this statement true and correct to the best of your knowledge and belief?
Yes, it is.
I tender a copy of the statement of Janine Mary Belling dated 20 May 2021.
Thank you. The witness statement of Janine Mary Belling dated the 20th of May 2021 and bearing the document identifier DLG.0001.0005.0001 is as an exhibit. Thank you. Ms. Cowell.
Just to clarify, I think what's been tendered is the redacted version that carries the _R suffix at the end.
Thank you.
Thank you, Commissioner. Ms. Belling, at the beginning of your witness statement, you describe your career at the department commencing from 1996. And I understand from paragraphs 6 to 9 that until the early 2000s, you were involved only in the liquor licensing area of regulation. You weren't involved in casino regulation, is that right?
That's correct, yes.
Just to pin that down a little more, if we go to paragraph 9, as I read your statement there, you are tying your first involvement in casino regulation to when the department was restructured to merge the liquor and gaming teams. Is that right?
Yes, that's right. Yep.
Could that have been as late as 2005?
No, it wouldn't have been. 2005, I was acting in the position of manager policies. So at the time that we, this is the licensing teams were merged well before that.
Right. So if I look at paragraph 6, we can ascertain from that you have a clear recollection of being involved in casino regulation when you were holding that position of senior coordinator. Is that?
Yes. Yeah, from a licensing perspective in terms of casino employees and raffles, that sort of community gaming activity.
Well, you identify at 9, I think, when you had that senior coordinator role that you were responsible for a team that processed all applications for liquor and gambling matters.
Yep, that's right.
And did that include approving junket tour operators back in 2000?
Potentially, but I would imagine that the function that licensing played in those early days was to receive and receipt the application, enter it, and make sure all the documentation had been submitted. And that would have been the extent of that.
Not actually approving the
No.
The tour operator, is your point?
Yes, that's correct.
So
we didn't.
Sorry, you finish.
Sorry, that is correct. We receipted the application, processed it, but didn't approve it, to the best of my recollection.
Right, so if we come back to 9 at page 003, where we are, and we just go down to the bottom there, the last two sentences, we're talking about casino regulation here, and you're talking about the aspects that you became familiar with, applications for approval of casino employees and unrelated to casinos, conducting raffles and community gambling, where you say beyond that, at that time I had no further involvement with respect to regulating casino activity. I think that given the answers you've just given to my questions, it could have also potentially included receipting and reviewing applications for junket tour operators to be approved, although you weren't involved in actually approving those applications.
Yes, that's correct.
All right. And do you know who did approve the applications back in those days?
Oh, look, to the best of my recollection, they went to the compliance team, and the compliance team did interviews, etc. And the approval would have been at the chief casino officer level, I believe, but my involvement really in those days was very limited.
Right, so you're not really sure about what that process was past your review of the documentation and passing it on?
Correct.
All right. Now, I understand you had, apart from that short time as a senior coordinator, you had no further involvement in casino regulation until you became Director of Licensing in May 2007. Is that right?
Correct.
And when you were appointed Director of Licensing, that covered the field. You were responsible for all regulatory areas, racing, gaming and liquor licensing. Is that right?
Yes, as well as the department's legislative agenda.
Now, we'll come to that. If we go to the job description for Director Licensing, which is GWC.000.002.0045, and hopefully that will come up on the screen, on half of the screen for you, Ms. Belling.
Yes?
This is a job description for the role of Director Licensing. There's no effective date, you'll see, just above that top box. But if you go to the footer, there it says 2020, the actual beneath that. We're going down to the footer, please.
Yes.
You see it says
April 2010.
And I think there is, in fact, an earlier version that has a footer at 2007 in the same terms. But in any event, do you recognise that as the job description that was applicable to your role as Director Licensing, to which you were appointed in 2007?
Other than for the unsigned component, and just above section 3 there on that front page.
Yes.
Where it talks about the positions under direct responsibility, that is not an accurate reflection of the team that I was accountable for, but otherwise it looks the same.
All right, thank you. We'll come to those reporting lines in a moment. But if we go to the chart above that box that you've just directed our attention to, does that accurately depict the reporting lines with you reporting to the Director General and you having relevantly 3 deputy directors reporting to you.
Yes, that looks right.
Now, there's one Deputy Director licensing policy.
Mm-hmm.
Can you explain what that role involved?
So the original JDF, the job description form for 2007 would have had different titles to those positions. So if my memory serves me correctly, the Deputy Director Licensing Policy was previously known as the Manager Policy.
Yes.
And that function was entirely responsible for ministerial correspondence, parliamentary council correspondence, the policy of the department and the policy of the Director of Liquor Licensing, the policy of the Gaming Wagering Commission, and the legislative component of the department's responsibilities. So, for example, if there was amendments to regulations or anything to that extent, that team was responsible for.
And who held that role between 2007 and 2012, do you recall?
Mr. Mark Beecroft.
Now, those other two, what are nominated here as Deputy Director Licensing roles, were those identical positions with the same job description?
To a large extent. One focused primarily on gaming and one focused on liquor. So the job descriptions were identical except for the reference, I think, and, you know, I'm happy to stand corrected without access to those JDFs. I think one focused on gaming and one focused on liquor.
And did they cross over? So was it possible from time to time for the liquor one to be involved in gaming and vice versa?
Yes. One of the things that we were doing in the department was trying to ensure that everybody in similar positions had shared knowledge, I guess, of the business of the agency. So the Deputy Director who was handling gaming things certainly from time to time was involved in making decisions around liquor licensing and vice versa.
Was there any focus on developing expertise such that the gaming Deputy Director should develop particular expertise in that area and the liquor Deputy Director expertise in that area? Or was it?
Yes, but I was very fortunate in that the two officers that held those roles were already experts in those two fields in any event. So, for example, Mr. Sandy Del Preti was the subject matter expert, I guess, in liquor, in gaming, and Nicola Perry did the liquor.
And what was Mr. Del Preti's background to make him the expert in gaming?
Mr. Del Preti had originally been an inspector within the regulatory team that looked at all of the gaming right across the board, from community gaming, racing activity, casino.
And do you know how long he had been a casino inspector at the time that you were appointed in 2007?
A long time. I think Mr. Del Preti, along with many of the inspectors, had been with the department for 10, 15 plus years.
Now, at paragraph 11 of your witness statement, you refer to the compliance team that didn't report to you directly, and you say that they performed inspectorial, audit and investigative functions. Was acknowledging that he had a period of time at the Department of Fisheries, but during your tenure as Director of Licensing, was it Mr. Connolly who was the Director of Compliance?
Yes, correct.
And when he was at Fisheries, who filled his role, Director of Compliance?
I believe it was Sandy Del Preti. There was acting opportunities at that time, but I believe it was Mr. Del Preti. There could have been some acting done in that position by Mr. Toyne or potentially Mr. Santo Menino, but I'm pretty sure it was Mr. Del Preti.
And so did that create an acting position under you in relation to the Deputy Director licensing, and I'll put in parentheses, gaming?
Yes, it would have.
And do you remember?
No, I genuinely don't know.
All right. Now, you say that you worked with Mr. Connolly closely in that compliance team. Can you give us some flavour of what that entailed in practical terms?
In practical terms, so we had a very close knit corporate executive team. So that corporate executive team was Mr. Barry Sargent, the Director General, Mr. Connolly, myself, and the Director of Corporate Governance, Vanessa Grant. And I think we were a very close-knit team. So between Mr. Connolly and I, we would have been daily sitting down, talking about issues, bouncing ideas off of each other around particular issues, and it could have been anything from corporate governance related activities, so HR related issues, to areas of concern around liquor. Mr. Connolly and I, for example, worked very closely together on the alcohol related harm inquiry in Halls Creek and Fitzroy Crossing. So we did a lot of work on those sorts of things together.
And
we had a very shared approach to the business of the agency.
And were there any key issues in relation to casino regulation that you recall working with Mr. Connolly in relation to during your tenure as Director Licensing?
Key issues. I'm not sure what you might consider to be key issues, but...
So, if you just pause, Ms. Belling, I'll help you there. So you just gave an example in relation to the liquor licensing area of something you recalled, this alcohol-related harm issue arising, I think what you said, in Halls Creek.
Mm-hmm.
So analogously, in relation to casino regulation, were there some sort of key issues that you remember being the subject of discussion and collaboration between you and Mr. Connolly?
Yeah, we certainly had some experiences. So bearing in mind that my background in terms of the casino prior to the 2007 appointment was very limited. So quite often issues that we came across were well and truly new to me. For example, we did have a situation where a customer of the casino had been barred by the casino operator, and that individual sought a review of the decision to the Gaming and Wagering Commission. And it was quite a sensitive and potentially controversial matter. So that was a new experience for me to deal with that. So that was quite a key decision, I think, for the Gaming and Wagering Commission at the time, a review, because as a rule, people didn't apply for a review of their banning order. So that was a significant issue. We also had, and again, my direct or intimate knowledge of it is very limited. There was, when the casino operator introduced a whole new IT solution, I think, at the casino, and I think that was called Psycho.
Yes.
So there was a significant learning curve on that, and Mr. Connolly, was far more across that than I am, that's for sure. But equally, that was a significant issue for us to look at. So there was it just depended, I guess, but it was those sorts of things that we worked hand in glove on.
Do you remember discussing, collaborating on any issues in relation to money laundering?
We had, so, and I couldn't tell you the when exactly, but when there was new legislation came in around anti-money laundering, AUSTRAC legislation came in, and the AUSTRAC representatives were obviously consulting with all of the various jurisdictions, and I recall we worked with the AUSTRAC people when they came to Perth. Both Mr. Connolly and I worked with them to sort of look at, well, what was the WA situation, what was going to be practical, what wasn't, because they were looking, if I recall, one of the issues that we talked about was what would be deemed the minimum dollar amount for the financial transaction to be required to be registered with AUSTRAC. So in terms of anti-money laundering, that was probably the first real time I'd become involved in discussions around that.
And did you have any subsequent issues in relation to money laundering that you worked with Mr. Connolly on?
No.
What about problem gambling?
In what respect?
Did you collaborate, discuss with Mr. Connolly any significant issues around problem gambling, particularly at the casino?
Well, the customer who sought to have a banning order removed had some issues around problem gambling, but the reality is the Gaming and Wagering Commission, every single time that they were looking at new EGMs, new electronic gaming machines, problem gambling and how did that machine function? Was it going to be consistent with the principles of electronic gaming machines, etc.? So that the problem gambling was, I would suggest, at the back of our minds and the Gaming and Wagering Commission's members' minds, nearly almost at every commission meeting.
Particularly in relation to EGMs is your point, is it?
Particularly in relation to EGMs, because as a general rule, community gaming was nowhere near on the scale of what the potential for problem gambling at the casino could have been.
And the potential for problem gambling you recognised and GWC recognised as a result of using EGMs. That was
one of the areas of concern, yes.
Well, the main area of concern in relation to problem gambling?
Well, it would have been the main area of concern. I mean, we had the Gaming and Wagering Commission had quite a significant focus on problem gambling across the entire casino floor, but EGMs are traditionally the area of greatest concern.
Right, just separately, I'm moving topics a little bit here, but just staying with that role of Director of Licensing, can you recall the extent of delegated power that you had in your capacity as Director of Licensing in respect of casino regulation?
Well, my delegation was the delegation of the Chief Casino Officer.
So you don't recall having any delegated powers purely in your capacity as Director Licensing in relation to casino regulation?
No.
Right. Now, just
my recollection would be, or my recollection is that my delegation was the delegation issued either under the Liquor Control Act, and in that case it was to the Director of Licensing, and in relation to the casino or to the Gaming and Wagering suite of legislation, it was Chief Casino Officer.
And just in relation to that role of Chief Casino Officer, you say in your statement at paragraph 10 that you believe you were appointed to that position sometime in 2007. That's
I'm sorry.
Paragraph 10.
Yep. Your question, sorry, you dropped out there.
Sorry, your evidence is to the effect that you believe you were appointed to the position of Chief Casino Officer sometime in 2007.
Yeah, look, I think it was directly linked to the role of Director of Licensing. So I was appointed to the position of Director Licensing, and very soon after there would have been a delegation issued by the Gaming and Wagering Commission to me as Chief Casino Officer. That's my recollection.
So Mr Connolly has given evidence to this Royal Commission in substance and in terms to the effect that he was appointed Chief Casino Officer in 2007, and he held that role until he went to Fisheries in 2010. But that doesn't accord with your recollection.
No.
And you remember a delegation of power from the GWC to you in your capacity as Chief Casino Officer?
Yes.
Do you recall an instrument of appointment as Chief Casino Officer?
Yes.
Now, and that was an instrument of appointment by whom? Who appointed you?
Well, to the position of Director Licensing, that would have been the Director General, but the instrument of appointment as Chief Casino Officer, I believe that was the Gaming and Wagering Commission. It could have been the Minister, but I couldn't be specific about that.
Now, paragraph 12 of your witness statement, page 0004, you mentioned that you, in this role as Chief Casino Officer, you represented GWC in its communications with the casino operator. Do you mean by that whenever GWC communicated through you with the casino operator, you always signed in your capacity as Chief Casino Officer?
No, I wouldn't have probably signed as Chief Casino Officer. I could have, but I suspect probably not.
So you would sign as Director Licensing?
Potentially. It could have said Chief Casino Officer, but without having documentation in front of me, I couldn't confirm that.
But is your position that however you signed the correspondence, you were only communicating with the casino operator because you had delegated power as Chief Casino Officer?
Yes, as a general rule. When we're talking Gaming and Wagering Commission, yes.
You know,
I dealt with the casino operator in my capacity on behalf of the Director of Liquor Licensing, though, as well.
we'll come back to that. Oh, as liquor licensing, yes, I understand. Now, just staying with you, corresponding in your capacity as Chief Casino Officer with the casino operator, do you know if the compliance team had its own set of written communications with the casino operator? What I'm driving at here, just to shorten it, is, or did all correspondence have to go through you?
No, not all correspondence had to go through me. I would suggest, but again, it's would be what I would consider would have been practically appropriate. I would have thought that the vast bulk of correspondence would have gone through Mr. Connolly. If it didn't come through me, it would have gone through Mr. Connolly. If the inspectors were dealing with the casino operator outside of that, it would have been on small scale issues, I would have thought, but I can't think of why that would have occurred, but it's possible.
Right, now I want to take you to paragraph 67 of your witness statement at page 0015.
Yes.
Where you say that the roles of Chief Casino Officer and Director Licensing were, in your view, interchangeable.
Sorry.
You never experienced difficulty in understanding your obligations and responsibilities across both roles. Just to tease that out, apart from sending correspondence in your position as Chief Casino Officer, did you distinguish in your mind between functions and responsibilities you had of regulating the casino as Director of Licensing on the one hand, and functions and responsibilities you had regulating the casino as Chief Casino Officer?
yes and no, if I can answer it in that way. For example, and I as I've just mentioned, my role was also as a representative of the Director of Liquor Licensing. So, you know, every application for a bar manager, for example, was dealt with under the Liquor Licensing Act. So I could be very clear about my responsibility in separating what was casino regulatory activity versus what might have been liquor licensing regulatory activity. I never had any issues of differentiating those.
Yes, but if we go to sorry.
Sometimes they could cross over. That was for sure. But
paragraph 68.
yes,
You identify things you did as director.
yes,
Don't on their face look to be related to liquor licensing.
correct.
When you say you did those things at 68 as a director, did you also do them as chief casino officer?
Yes.
Did you ever turn your mind to the extent of delegated power you had as chief casino officer relative to the extent of delegated power you had from the GWC as a director, and whether they were the same or different?
In my view, they were the same. I didn't get, to the best of my recollection, I didn't have any delegation as director. I had delegation as chief casino officer.
Right, thank you. So if we go back to paragraph 22 at page 006, and you say you exercised your CCO functions and responsibilities on a part-time basis. Do I understand from the evidence that you've just given that what you are saying there is that you performed casino regulation duties and responsibilities on a part-time basis?
Yes.
And that's what you mean when you say you put on your CCO cape
Yes.
almost every day. When you
Yes.
put on your CCO cape, you were performing casino regulation duties and responsibilities.
Correct.
Now, at 23, you describe a significant tension between, is it fair to put it this way, your casino regulation responsibilities and your non-casino regulation responsibilities? Yes?
Yes, that's right. My job was very fulsome. It was I was, for all intents and purposes, the 2IC of the agency. So my responsibilities went far and beyond Chief Casino Officer role.
So you see at the last sentence of 22, you estimate that you spent around 30% of your time on casino regulation as opposed to your other responsibilities. Is it your position that that wasn't enough time? It would have been better if you could devote more of your time to casino regulation?
Oh, look, ideally, yes. In a perfect world, yes.
And about using those percentages as a guide again and appreciating that it would just be an after the event estimate, about how much of your daily and weekly time do you think it would have been adequate to discharge your casino regulation responsibilities?
I suspect any of my colleagues would probably say that I was obsessive compulsive in a lot of ways, in that ideally I would have liked to have spent a much more significant amount of time learning and working on casino activities. The casino industry and online gaming, it is a fast evolving area and very dynamic. And, I think, and as time progresses and that industry matures, it is a very sophisticated industry, and I would have loved to have spent much more time on it.
Well, full-time, is that what you're saying?
Full time would have been lovely.
Well, lovely is one thing. Necessary? Would you have thought it necessary to have a full-time director in relation to casino regulation?
Today, yes, I would. And if I can expand on that, I say today because the industry, the casino regulatory industry today is a completely different beast to what it was in 1985 and even in what it was in 2005. It is a very, very sophisticated industry these days.
Well, you refer to that, I think, in paragraph 23 when you identify, I think you used the word of complexity to describe the casino regulation landscape and the fact that it's a changing landscape. I think you referred to the advent of online gambling internationally as being one aspect of that. So can you just elaborate a little further for the commissioners on what the challenges are, what the complexity is, and what challenges that brings to for a casino regulator?
Okay, well, probably if I can use an analogy. So back in 1985, we didn't have personal computers. When the casino first started in Western Australia, there was no such thing as personal computers. Fast forward to 2021 and people walk around with an extraordinary piece of technology in their hand, and that device allows them to gamble any place, any time. So in terms of, my view would be that government legislation and certainly casino regulation, it is such a fast moving landscape and industry that the regulators have to be able to respond to that swiftly. And those changes can happen, well, they can happen almost overnight, but certainly year to year it's never the same. And the way people gamble changes quickly. People learn and evolve their gambling activity quickly, and the technology and the IT solutions out there to cater to what the gamblers want to do is a very fast-moving technology. So it's not an environment today where the way we did it back in the 1980s and 1990s would ever be suitable.
Do you see those issues that you've just identified, developments in technology, changes in the way that people gamble with that technology, as having relevance to the regulation of bricks and mortar casinos today?
Oh, yes, I guess they do. In fact, I suspect there'd be a lot of bricks and mortar casinos who, well, certainly we were talking about it in 2000. I think I went to an international gaming regulators conference in South Africa, and I think that was around, I think that was probably 2011. And in 2011, the discussion was around how bricks and mortar casinos, in order to be able to compete in this online world, were having to look at how can they also deliver their product online from a bricks and mortar casino. So, you know, it was very, it was a conundrum for every casino regulator around the world as to how we were going to do that.
In order to preserve bricks and mortar casino operations?
Well, not necessarily preserve, because the roles of casino regulators is not to preserve, but it's certainly to aim to protect the integrity.
And do I understand from that if bricks and mortar casinos then went into the space of offering online gambling opportunities, that's where the regulator would have an interest in regulating the integrity of that style of gaming?
Yes, if it was possible to do so. And that was the challenge back then. I can't even imagine what regulators are faced with currently.
Now, just coming back to that role of CCO, can I just ask you to clarify something at paragraph 63 of your witness statement, page 0014? Just down the bottom of the page there, paragraph 63 sits underneath a heading that says delegation of CCO powers to GWC officers. Are you saying here that you yourself, in your position as CCO, delegated powers that you had, you on-delegated them to officers of the department?
No, look, I without seeing a instrument of delegation, I don't believe it would have been me or the CCO who delegated those powers. I believe it still would have been a Gaming and Wagering Commission delegation, but I honestly can't be sure of that.
Thank you. Now, just in relation to delegations generally, can you recall whether, whenever delegated power was exercised by a department officer, including yourself, in whatever capacity, was GWC typically informed of the fact of the delegated power having been exercised?
Yes.
And how did that occur?
I reported to the Gaming and Wagering Commission each month, or whenever we met, and I believe it was monthly, on all licensing applications and the delegation of power under, the exercise of delegations for licensing.
Now, at paragraph 14, page 0004 of your witness statement, you mentioned being delegated the responsibility of deputy chairperson of
Yes.
GWC. You were in fact appointed deputy chairperson, weren't you?
Quite possibly, yes.
Let's have a look at pub.0008.003.001 at page 0022.
Can you, thank you.
And if we just drop down, please.
Yes.
So you see there an appointment in October 2008 of you as deputy chairperson, albeit that it's reflecting an appointment made much earlier, May 2007.
Yes.
Do you recall the reason for the gap in time between the gazettal of the appointment and the actual appointment?
That's the way the legislative program worked. The policy team would draft or work with Parliamentary Council on the drafting of regulations, etc. And this is an example of that. That would then go through Parliamentary Council before finally being delivered for promulgation.
Do you recall if you exercised...
So the agenda, I can't comment on the process and the agenda of Parliamentary Council or whoever else, but that would probably be the reasoning.
Do you recall if you exercised any powers in the position of or as Deputy Chairperson before the gazettal of your appointment?
What date are we talking? 2008. I would have only... or potentially, it depends on whether or not Mr. Sargent went on holidays.
In any event, you saw your role as Deputy Chairperson as very limited, simply chairing meetings in his absence. Is that right?
That is the only time I exercised it, yes.
Right. So you didn't exercise any delegated power from the GWC otherwise in that capacity?
No, I did not.
I'll tender the gazettal, Commissioner Owen, pub.0008.003.001. Probably only need to tender page 0022.
The Government Gazette with the notation for the 6th of October 2008, with the document identifier that Ms Cowell has just read out, is admitted into evidence as an exhibit.
Thank you, Commissioner. Now, just returning to the job description that we were looking at a little while ago, GWC.0002.002.0045. In section 3, down the bottom, on that page,
Thank you.
I had the same problem. It refers to providing high-level decision, making binding high-level decisions in accordance with relevant legislation and delegation. Do you see in that second paragraph?
Yes, yes.
And in the third paragraph, second sentence, provides high-level advice to support the development and implementation of policy and legislation that is consistent with government direction, legislative and customer requirements.
Yes.
In relation to the casino regulation, who would be the customer you would identify as having a requirement in that circumstance?
Well, it could be everybody from members of the community, Western Australian community. It could well have been the operator.
All right. Now, the provision of high-level advice, a high-level advice to whom?
In relation to the casino,
Yes.
the Gaming and Wagering Commission, the Director General in his capacity as chairman, and even to the Minister.
Now, if we can just switch back to paragraph 15 of your witness statement at page 0005. Describe having primary accountability for the legislative agenda for the department. And at 33, paragraph 33 at page 0008,
Yes.
you talk about in terms the existing legislative framework establishing the purpose, duties and responsibilities of the GWC and the Chief Casino Officer as to relevantly casino regulation. What do you discern from the Casino Control Act and the GWC Act is the legislative purpose of regulating casinos and the operation of casinos in Western Australia?
To regulate and control the activities in relation to the casino, sorry, you said?
What do you discern from the Casino Control Act and the GWC Act is the legislative purpose, or the legislative objective of regulating casinos and casino operations in Western Australia?
Oh, in simple terms, it's to ensure the integrity of gambling in line with principles of harm minimisation in the interests of the Western Australian community. That's simple terms. I mean, you could pull out the legislation and read the objects, but yeah, that's the simple terms.
Anything else?
I don't have the legislation in front of me, and we're talking, 10 years ago. So no, I couldn't tell you.
Is one of the legislative objectives to protect the revenue stream for the state from casino operations?
Look, the legislation, all pieces of legislation will have a primary purpose. Then subsequent to that, the legislation will always identify various other additional responsibilities and obligations. And yes, that would certainly be one of them.
So just to be clear, I'm just asking you what your understanding of those legislative objectives were. I'm not asking you to interpret the legislation for me, just what your understanding was at the time.
Yes, certainly.
So did it include, your understanding include protecting the revenue stream as a legislative purpose?
Yes.
And in terms of ensuring the integrity of gambling, did it include, on your understanding, ensuring that the casino operator remained a suitable person to operate the casino?
Yes.
And what was your understanding about the scope and content of suitability in that context?
Suitability would be the fitness and propriety of all of the individuals involved. And that would extend to the entity's history and background in terms of the conduct of businesses. We would look at issues around criminality, whether there was any criminal history attached, whether that was an individual person or even as a corporate entity. So it's quite a wide gambit of issues.
Now, if we go to paragraph 36 at page 0009 of your witness statement, talk about undertaking internal policy and procedure reviews. This is throughout your career.
Yes. Yes.
To eliminate, at the department, to eliminate gaps, red tape, clarify the legislative framework. Go on to describe a little bit more about that. Now, the elimination of gaps, are you talking about gaps in the legislative framework as well?
It could have been, yes. You know, it was certainly, I mean, clearly to amend an act is a significant legislative change, but regulatory was a little bit more straightforward. So if we identified I can't even think of a good example for you, but if we identified something that there was a flaw or an inadequacy or a duplication in the regulation, then we would certainly look to recommending an amendment if that was appropriate.
All right, if we go back to paragraph 16, please, which I think is at page 0005. Just zoom out so we can see 15 as well for context. So you're talking there about having primary accountability in 15 for the legislative agenda of the department during your tenure as Director Licensing. And at 16, you identify legislative reviews for which you were accountable as Director during that time.
Yes.
So was the process taking a piece of legislation such as the Racing and Wagering Western Australian Tax Amendment Bill or the Liquor Control Amendment Act and reviewing it to see whether it was adequate and appropriate to achieve the proper policy objectives?
Yes and no. I mean, if I can pull out the Liquor Control Amendment Act, that was a significant piece of legislation. In fact, that was the whole of government's number one legislative program. I think when we did the amendment bill was probably 2005 or 6. That was a huge project. So that's quite a different, that was a complete review of the liquor, it was called the Liquor Licensing Act back then. That was a complete review that had the Fremantle committee did a review of that. So that's quite a separate example. The other pieces of review would have been, so for example, out of that Liquor Control Amendment Act, there were subsequential amendments that needed to be made to other pieces of legislation and quite possibly the racing and wagering legislation, certainly even the gaming and wagering legislation, if I recall. So you would have had a flow-on effect, so to speak, from that review. But outside of that, we would be making amendments. We didn't do reviews of an entire piece of legislation, or that's certainly not what you did on a regular basis. Racing and Wagering Legislation Amendment Bill probably was a big review because lots of changes were occurring to how RAWA functioned back then. But outside of that, they would be minor amendments, consequential to other legislative changes or regulations that just were no longer relevant, or new ones that were.
So you didn't have a responsibility to look at, for example, the Casino Control Act or the GWC Act and ascertain whether it met in whole or in respect of specific areas the policy objectives of government or the legislative purposes for which that legislation was introduced.
I would have had responsibility had the Gaming and Wagering Commission or the government of the day required a review of the nature you're referring to.
I see. So
that was not.
You didn't drive that agenda. You reacted to an agenda set by others.
In terms of an act, a legislative agenda such as an act, absolutely, that was a government decision. Regulatory was somewhat different. You definitely looked at regulation on a more regular basis.
Right, but let me just understand at a further level of detail. So government of the day would drive the agenda, for example, whether there's to be a wholesale review of liquor regulation in the state or casino regulation in the state.
Yes, correct.
But what about specific issues? So, for example, a question as to whether or not the current Act, the Casino Control Act, adequately regulates issues of suitability of the casino operator. Would that be something that would be driven by the government of the day to which you would act at their direction, or was that in terms of policy and legislative objective something within your remit to identify and then pursue?
I wouldn't have said it was within my remit, but it was certainly, and if I can go back to the example I gave around the changing landscape of the casino environment. When I returned from the international conference in South Africa, I presented to the Gaming and Wagering Commission the outcomes and the issues that were under discussion at that international conference, and highlighted, this is a fast-moving, technologically sophisticated environment, and we need to think about how the Gaming Wagering Commission needs to think about how it's going to regulate casinos into the future in light of that changing landscape. So yes, there was absolutely some responsibility on me and on others who might have observed things that thought, the legislation is no longer capable or fit for purpose or whatever the case may have been. And we could present that to the Gaming and Wagering Commission, and after that it was whatever the Gaming and Wagering Commission, in consultation with the government of the day, would then drive it.
Right. Now, in that regard, Ms. Belling, can I ask you, during your time as Director Licensing, did you give any consideration to the policy and regulatory framework, whether it adequately regulated electronic gaming machines?
Did I? No, I would say I didn't, primarily because it wasn't my area of expertise. I certainly gave my views and my opinions, if asked, in terms of what I thought might have been an alternative view to take. But the design, if I can call it the design, or the technology of electronic gaming machines, was certainly not my area of expertise.
What about problem gambling? Did you consider the policy or legislative framework to see whether it was adequate to address problem gambling?
We did. And I think I mentioned earlier, any time an electronic gaming machine, for example, went before the Gaming and Wagering Commission for approval, we always took into consideration how did that machine fit with the government's philosophy and the Gaming and Wagering Commission's principles of separating electronic gaming machines and differentiating electronic gaming machines from poker machines, for example. So, yeah, and I think the Gaming and Wagering Commission recognised that where once upon a time it was probably much easier to identify what's an EGM versus what's a poker machine. Technology was changing, and that was going to become harder and harder to do. And the government's policy position might well have needed to change.
So outside of EGMs, did you consider the suitability of the policy and legislative framework more generally in relation to problem gambling?
No, because I think the WA, out of all of the jurisdictions, was probably doing very well in terms of as best as it could in terms of protecting the community from the harms of problem gambling.
How does WA rank, do you know, in relation to levels of problem gambling and how those levels are dealt with compared to the rest of the world, not other states in Australia?
I couldn't comment on that today.
Is that something that you looked at when you were in that role of director licensing?
Yes, and I say we because it was always done in consultation with the Gaming and Wagering Commission. We were always looking at, well, where are we at? Where do we sit compared to other jurisdictions? We primarily looked at Australia, that's fair to say, because our landscape in terms of our legislative framework in Australia was clearly very similar. You couldn't necessarily compare our situation in Australia to, for example, the UK. Very different landscape, very different principles and philosophy around gambling. But yeah, we definitely did look at where were we at, how are we doing, what are other jurisdictions around the world are doing something really innovative and interesting, and is that something that we can utilise? Can we find a place for that in our jurisdiction?
Did you consider or review the policy or legislative framework to see whether it was adequate to ensure that the casino operator remained suitable to operate the casino?
Did I consider the legislative framework? Sorry, I missed that, your question.
The policy and legislative framework to see whether it was adequate to maintain the casino operator as a suitable person?
No, I did not.
And is there any reason that you didn't?
No, not that I can recall.
Right, different topic here somewhat, Ms. Belling. I want to ask you about some regulatory risks which are referred to in your witness statement under the label risks in block capitals, these being risks associated with junket operations, money laundering, cash and electronic transactions, and criminals infiltrating casino operations.
Yes.
Recall that as at 2007, there was a requirement pursuant to regulations made under the Casino Control Act for junket tour operators to Perth Casino or their representatives to obtain the approval of GWC.
Yes.
I'm going to ask you some details about that, about the details of that procedure in a moment. But first of all, at the time you were Director of Licensing, that is from 2007, you understood there to be broadly a two-stage process, did you, of gathering information via documents and interview in the first instance, yes?
Yes.
And then a second stage of the consideration of that material as to whether to approve the junket tour operator or not.
Yes, correct.
Did the compliance team undertake the first stage of gathering information?
No, the licensing team would have received and receipted the application and ensured that documentation for its completeness, for want of a better description, was all there. And then it would go, and again, this is my recollection, it would then go to the compliance team for them to do their interviews.
And then who actually made the approval decision?
I believe, but again, it's only my recollection that they went to the Gaming and Wagering Commission.
So no one at departmental level, you recall, approved junket?
I don't believe so.
All right.
But I could be wrong, but I don't believe so. I don't believe I was approving junket operators.
Do you recall if you had delegated power to approve junket tour operators?
I suspect I did, yes.
But your recollection is notwithstanding that went up to GWC for approval?
Yes, correct.
And that would have been done on the recommendation of an officer of the department?
Yeah, usually every application or every issue that went before the Gaming and Wagering Commission was always appended to a agenda paper, and those agenda papers would have a recommendation in it, yes.
And which team made the recommendations in relation to whether to approve a junket tour operator or not?
I suspect it changed over a course of time, but towards the end of my time, it would have been the licensing, the supervisor, team coordinator. I'm not sure of the titles of the positions, but it would have been a senior member of the licensing team who submitted their paper.
And would you oversee that before it went to GWC? Would you review it?
Yes, I saw all of the papers before they went to the Commission.
And when you say it changed over time, who originally would make those recommendations when you started as Director of Licensing?
Quite possibly came from the compliance team. The department was going through, we had numerous restructures, and with every change of government, there was a machinery of government pretty much. And so we definitely had a organic, the evolution of the department over a course of time.
So this was just a structural thing as to how teams were organised that influenced whether at one point in time or another it was licensing or compliance making the recommendation.
Yes.
Now at page 0010 of your witness statement, paragraphs 43 and 44, just before I tender a document, job description. Yes, thank you. I'll just, before we get there, Ms Belling, just tender the job description, Commissioner, GWC.0002.002.045.
That document is admitted as an exhibit.
Thank you, Commissioner. Now, at 43 and 44, you're talking there about, in a little more detail, about the procedure for approving junkets. And I understand that to time date this, you're describing the procedure as you recall it immediately prior to the repeal of the regulations in 2010.
Yes.
So the familiarity with the procedure that you obtained between 2007 and 2010, is that right?
Yeah.
And you're referring to what you describe as probity assessments of individual operators?
Mm-hmm.
What, on your understanding, was the purpose of the probity check or assessment?
We were checking to see if they were a suitable person to be involved in that particular activity. We would do, I think the applications in terms of junket operators had to be accompanied by a police report. And then we would also look at what was their history. Had they been approved previously in the past? Was there any notes against their record as a consequence of any previous approvals that might have been issued? So it was a bit of a dive into who were they and what were they wanting to do.
All right, so having a criminal history was relevant to know as to whether they were suitable. Is that
Yes.
right? And
yes.
What other types of information apart from a criminal history were you interested in relevant to this question of suitability?
Without any examples, I would probably argue I would have been interested in had they been bankrupt.
Why was that relevant?
Well, it was something that we looked at even in relation to liquor and the role that people would, if you were going to be a manager in a premises. If you'd been bankrupt, what was the circumstances of that bankruptcy, and did that make the individual susceptible, I suppose, to financial pressures and poor decision making as a consequence? So that would have been my thinking.
Now, irrespective of an applicant's individual or personal criminal history, were you interested to ascertain whether they had criminal associations, particularly with organised crime, that is, foreign crime syndicates?
Oh, yes. But would we have known if they were involved with foreign crime syndicates? Not unless the Western Australian Police had raised that. But yes, if it came to our attention, or it came to my attention, that the applicant was a close associate of an outlawed motorcycle gang member, for example, yeah, that was definitely a relevant issue.
Now, just in relation to the police, I gather you give evidence at 43 to the effect that until 2010, that is the repeal of the regulations, you recall the police or the department conducting probity checks through the police, the WA Police.
Yes.
But in fact, the police had ceased involvement in the junket tour operator approval process prior to 2007, hadn't it?
I don't know. I have seen in the testimony of others that that's the case, but I understood that we were getting police reports.
Well, you weren't close enough to the actual process of gathering documentation and processing it to know. Is that the case?
In terms of all applications, junket operators, I will admit, I did not have a great deal of knowledge of, but in terms of all applications, positions of authority, so to speak, we got police reports. But that was the standard procedure for my team.
To the extent that your team was responsible for making recommendations to GWC about whether to approve an operator or not, did you involve yourself in understanding what information had been gathered, what the process was, and who was involved in it?
I didn't see most of the applications. They would come into the licensing area. The licensing area, as I say, receipted, gathered the information that was passed then on to the compliance team, and then a recommendation was made as to its approval. I would read the paper before it went to the Gaming and Wagering Commission, but that was the extent of my involvement.
Well, you also described a little earlier in your evidence that over time it came to be the position that your team was the one making the recommendation to GWC about whether to approve or not.
Yeah, potentially, yes.
Did you consider it your responsibility to, at the very least, understand the procedure for approval and what it involved?
Yes, I did. And the procedure, to best of my recollection, was that we obtained a police report.
But I understood you to say a moment ago, because you weren't directly involved, having listened to the testimony of others to this Royal Commission, you couldn't be sure whether the police were involved during your time or not.
To the best of my recollection, they were providing a police report. It was news to me what others were saying.
A police report about what, Ms. Belling?
The police reports were pretty basic, and it might have only said there is no reason. Look, I couldn't even tell you the wording of it. It might have been as simple as saying that the Commissioner of Police is of the view that this person, there are no antecedents attached to this person that would cause or raise any reason not to grant approval. It could have been something as simple as that. Or it could have been this person is not deemed or not considered fit and proper for the following reasons, and it would list their criminal convictions.
Might you be confusing a police report obtained for liquor licensing purposes or some other regulatory purposes with the process that was followed for approval of junket tour operators?
I could be, but as I say, that's the best of my recollection.
It's a convenient time, Commissioner.
Thank you. We'll resume at 11:35.
All rise.
Thank you. Please be seated. Thank you. Ms. Belling? Yes, Ms. Cale.
Thank you, Commissioner. If I can go back to your witness statement, Ms. Belling, at paragraph 43, page 0010.
Yes.
Now, you're talking there in the middle of that paragraph about your recollections around the repeal of the regulations requiring the approval of junket tour operators, amongst other things, in March 2010, and you say you don't recall being involved, and you mentioned that you were absent on leave without pay in mid-2009 until March 2010.
Yeah, I think that's around those dates.
Yes. So who acted in your position as Director of Licensing during that period?
I believe it was Mr. Connolly.
And also holding the position of Director of Compliance at the same time?
Oh, I doubt that. I'd be very surprised. He wouldn't have had the capacity.
All right. Can I just show you this document? I think it's the minutes of the meeting of 23 February 2010, GWC.002.0016.0020. You see there, Mr. Del Preti is nominated as Acting Director Licensing.
That would be right. Okay.
So I'm just asking you whether that helps with your recollection.
No, not particularly because I was absent, but it would make sense, I guess, because I don't recall the dates when Mr. Connolly went to Fisheries, but that would suggest he was at Fisheries at that point in time, but I wasn't there, so.
All right. So, yes, you weren't there, but presumably you had some sense of who was doing your job in your absence.
Well, it was Mr. Connolly when I went on leave, and I was absent for 9-10 months, thereabouts.
So
changes that occurred in that period of time, look, seriously, I don't remember.
All right.
But looking at that, that would make sense. The timing seems right.
So when you first went on leave, you understood Mr. Connolly took over your position in an acting role?
Yes, he did.
And did he take over your role as CCO?
I presume so, yes.
Did he take over your role as Deputy Chairperson?
I presume so.
And you're not sure of who took over those positions while you were still on leave when he went to Fisheries?
No, I wouldn't have been involved in that decision.
And just to be clear, just when you went on leave and you were aware of him Mr. Connolly taking your position as Director Licensing,
Yes.
were you aware of who at that time took over his position?
No, I genuinely don't recall. I'm going to guess that it was Mr. Del Preti, but look, I don't recall.
That's just a guess.
Yeah, that's just a guess.
All right. Now, can I take you to the agenda paper relevant to the repeal of the regulations in February 2010? That's GWC 0002.0016.001_0337. Now, you've had a look at this agenda paper in preparation for giving evidence this morning, haven't you?
Yes, briefly, yes.
Right. So you've got a broad understanding of the subject matter of the paper?
Can you zoom in on that a little bit more for me, please? And I believe this is the paper where Mr. Toyne gives all the background around AUSTRAC, the AML legislation, is that correct?
Yes.
Yeah, okay. Mm-hmm.
Now, the subject matter of this paper, bearing in mind your experience of the division of responsibilities between licensing and compliance at this time, which stream or team...
Which one do you want to use?
I'm sorry. Sorry about that. I've got gadgets going off here. Sorry, say that again.
We all understand. We've all been there. I'll start again. Looking at the contents of that paper
Yes.
and remembering back at that time your understanding of the demarcations between compliance on the one side and licensing on the other,
Yes.
which team would have had the responsibility for actually presenting this paper, compliance or licensing?
Presenting the paper would have been the chief casino officer, but it could well have been, and in this case it was Nick Toyne. It could well have been prepared by compliance or licensing.
So either one or other team you could have been responsible for initiating this paper and preparing it.
Yes, they could. I mean, you've used the word demarcation. We weren't a big agency, you know, and in a small agency, we worked as a team. So I don't necessarily think I would have referred to as demarcation, but Nick Toyne in this case has prepared it and he was licensing. So
Mr. Toyne was licensing.
Well, according to this, he was acting deputy director licensing.
Or do you remember?
I wasn't there. I was not present at the time.
Understand. Before you went on leave, do you remember where Nick Toyne was located?
No, I don't.
Before you went on leave in mid-2009, was there any discussion or consideration by the department of which you were aware or in which you were involved regarding the repeal of the regulations for the removal of that requirement for approval?
No, I don't specifically. As I've indicated in my statement, I've got a very vague recollection of that time and a vague recollection of discussions. Well, we were certainly having meetings with AUSTRAC. So it's only a vague recollection.
Do you recall any particular person in the department particularly pushing for the approval requirement to be removed?
No.
What was your view in 2009, 2010 about the merits of removing the requirement for approval and the cessation of probity checks?
Look, I don't recall, except it would be my my knowledge, I guess, of what AUSTRAC was doing and what that new legislation was proposing to do, that I guess I probably would have taken, and this is a reflection back, I can't be sure, but I probably would have taken the view, well, here's this new piece of legislation by this agency who's got extensive expertise and capacity in relation to probity and investigative powers in relation to organised crime and money laundering, etc. So I probably wouldn't have been opposed.
So where did you get that information about the scope and content of the AUSTRAC functions and responsibilities?
Well, if you recall, I think I mentioned earlier that I remember meeting with AUSTRAC at some point to discuss the anti-money laundering legislation, and as I would have been my nature to do, I would have looked into, well, who is AUSTRAC? What is their powers and responsibility? Why does this agency exist, and what's this legislation that's being proposed or enacted? So I would have just researched it.
Would you have actually reviewed the legislation?
Would I have reviewed it? Not in a formal capacity. I would have read it, but it wasn't my gambit or remit to be reviewing it.
So when you read it, did you form a view that AUSTRAC investigated money laundering?
I knew that the function of AUSTRAC was to identify, investigate, and disrupt criminal infiltration of Australia's financing system. I knew that that was their function. So, yeah, I guess I probably would have reached the conclusion that the legislation supported that or enabled that.
But that's what AUSTRAC actually did. That's a conclusion you formed.
Yes, it was.
Can I come back to paragraph 44 of your witness statement, please? 0010 is the page number. You see there in the first sentence, you say, outside of the pre-2000 function of conducting a probity assessment, etc. Is that a typographical error? Should that say pre-2010?
Yeah, it probably should be. I was reading that before and I can't quite get my head around that, but yeah.
You also mention here at this part that the Casino Operations Manual placed obligations on the operator to satisfy themselves about the probity and conduct of junket operations.
Mm-hmm.
Was that before the repeal of the regulations or after?
I could not comment on that.
Do you recall what those requirements were?
No, I do not.
Do you know if, and if so, what audit or inspection programs were developed and conducted in relation to those manual requirements?
Sorry, can you repeat that?
Do you know if any audit or inspection programs were developed by the department in relation to those requirements in the manual?
Audits and inspections were always developed around various aspects of the operations manual. I would assume yes, but again, I can't recall that specifically.
Independently of any obligations that the casino operator had through the Casino Operations Manual, were there any other requirements imposed upon the casino operator after the repeal of the regulations in relation to junket tour operators?
Not by the Gaming and Wagering Commission that I recall, but I believe the AML legislation, so the anti-money laundering legislation, certainly imposed requirements to report financial transactions above a certain figure. Report and record. But again, that's just my recollection.
Now, apart from the conclusions you reached about what AUSTRAC was doing once the AML legislation was introduced, did you take any steps after the regulations were repealed or before to ascertain whether any other law enforcement agencies were in fact adequately addressing the risks of money laundering through junket tour operators?
Well, with respect, I'm not sure this witness could say whether any other law enforcement agency was doing something in an adequate fashion or not.
Sorry, I'll rephrase the question. I meant to frame it in the same way as I did in relation to the AUSTRAC legislation. Did you investigate and form any conclusions about whether other law enforcement agencies were adequately addressing the risks of money laundering through junket tour operators?
No, I did not.
Is there any reason for that?
I couldn't recall a specific one other than to say I probably was immersed in one of many other responsibilities, I guess. But no, I don't know, to be honest.
Do you think, looking back now, that's something you should have done?
Everything's wonderful in hindsight, isn't it? Yes, I guess, in fact, what I would probably, if I could, on reflection, what I would probably suggest would have been a good approach to have taken was when the AML legislation came in and AUSTRAC took on a greater focus, I guess, in relation to anti-money laundering and criminal infiltration of financial systems. The Gaming and Wagering Commission could have developed a more robust relationship with AUSTRAC and even potentially had a memorandum of understanding around that, around how information could be shared.
You say at 42 of your witness statement, that's at page 0010, that the department and GWC was not equipped or skilled to detect, investigate and manage more complex matters. But you would accept, wouldn't you, that it had powers to require the casino operator to provide information to it that would reveal the indicia of possible money laundering?
I accept that the Commission had the power to request that information, yes.
And that the department or GWC could then pass that on to relevant law enforcement or government agencies for them to exercise their skills and use their resources to uncover any criminal activity in that regard?
Yes, and I guess that's where a more robust relationship and a memorandum of understanding would have been a beneficial outcome.
And you accept that the department and GWC had powers to audit and inspect the casino operations to itself, detect the indicia of possible money laundering?
It had the powers to, yes.
And that would not necessarily require significant skills or resources. It could involve simply reviewing bank transactions to expose transactions that were suspicious?
No, I disagree entirely on that score. This organised crime is highly sophisticated. I do not believe, and I would be happy to be corrected, I don't believe you could pick up a bank statement and identify from a bank statement whether organised crime is involved in money or money going through the casino.
Well, what about a bank statement that reveals 3 deposits or 10 deposits, each of $9,000 by the same depositor on the same day, Ms. Belling?
That would not necessarily be indicative of a criminal offence, I wouldn't have thought.
But it might, Ms. Belling.
But it might, yes.
And that could be obtained and passed on to a law enforcement agency for it to investigate further, couldn't it?
Yes, that's correct.
And that's adequate, comfortably within the skill set of the department to undertake that sort of audit and inspection of bank accounts.
Yes, I guess so.
Yeah. So in that regard, do you know if the department did during your time routinely inspect, audit or review the casino's bank accounts?
No, not that I'm aware of.
So do you remember that that didn't happen, or you simply don't recall one way or the other?
I don't recall one way or the other.
And do you accept that the department and GWC during your tenure had the power to require the casino operator to follow procedures that would mitigate the risks of money laundering or criminal infiltration?
I'm really sorry, Ms. Cahill, you dropped out then.
Do you accept that the department and GWC had the power to require the casino operator to follow procedures that would mitigate the risks of money laundering or criminal infiltration?
Yes, I do.
Your recollection at 44 of your witness statement is that the manual placed the manual placed obligations on the operator to satisfy itself about the probity of the junket tour operator.
Yes.
Well, that's something that the department or GWC could equally do, couldn't it?
Yes, yes.
Did you ever give consideration to obtaining external advice in respect of the casino operations manual to review it as to its adequacy to address and mitigate the risks of junket operations, money laundering and criminal infiltration?
I did not know.
Moving away from the specific risks associated with junket operations, money laundering, cash and electronic transactions and criminals infiltrating casino operations, and looking at the regulation of risks of casino operations more generally, say at 39 of your witness statement, page 0009, that GWC and the department during your tenure primarily operated on a risk-based approach.
Mm-hmm.
Now, in your understanding, did a risk-based approach involve first identifying the risks associated with the casino operation,
Yes.
and then secondly, assessing what those the significance of those risks in relation to the operation of the casino,
Logically, yes.
and then thirdly, working out an effective way to mitigate those risks.
Yes.
Were you involved at any time in your tenure of identifying and or assessing risks associated with the operation of the Perth casino?
Only in a very broad sense, and in that regard, I would use the example I gave earlier around online gambling and the risks that might well have posed, and that was something that we should be looking at.
Well, that was really just a response to that topic having been raised at a conference you went to, wasn't it?
No.
So
I mean, that, sorry.
No, you go.
No, I mean, we were constantly having dialogue with other jurisdictions in Australia as well as around the world. It was certainly a subject of conferences at that time, but you don't work in the field of casino regulation without having an ear to the ground on these things. And so online gambling, by nature of the changing technologies, was a looming issue for us, regardless of what conferences discussed. So that's an example, I guess, of where I broadly would have been identifying risks.
When you look back now, again, using the hindsight that we all have, do you consider that you ought to have taken it upon yourself to look more broadly at the risks associated with the operation of the casino and undertaken a risk identification and risk assessment procedure more holistically?
Oh, with the benefit of hindsight, and had I had more time, yes, absolutely. I would have liked to have been able to do that.
Now,
Or part of that, because, you know, again, not one person can achieve all of that. So it would have definitely been something that Mr. Connolly and I would have sunk our teeth into, I imagine.
now at 39, where I took you a moment ago, you go on to describe GWC and the department's primary reliance upon the risk-based approach with regular programmed and random inspections and audits. So that's, you're referencing the work of the inspectors there, aren't you?
Correct.
Now, did you have any appreciation at the time that you were Director of Licensing as to whether the resources applied to that inspection and audit function were sufficient or not sufficient?
Oh, I think any public servant, a senior public servant, would probably argue you can always have more resources and you would always love more capacity. I think it would be very reasonable to say that Mr. Connolly and I would have loved for there to have been more resources available in the inspectorate team.
Or whether or not you would have loved for them to have more resources, did you think at the time that more resources were necessary, that they were needed?
Yes, for delivery of services across the broad range of the department's responsibilities, not just in relation to casino.
Well, asking you to focus on casino regulation specifically, were more inspectors needed to regulate the operations of the casino?
I didn't believe so, but the management of the compliance function was Mr. Connolly's, and I would have relied entirely on his advice in that, and whether or not he thought we needed more resources or not.
So you didn't have a view?
Well, I've just expressed that. My view was that the department needed more resources generally.
But not in relation to casino regulation?
Well, I think if you recall from previous testimonies that the inspectorate team provided functions. So we no longer had a dedicated team of inspectors at the casino. We had a team of inspectors who provided functions across the broad gambit of the department's responsibilities. And that team could well have done with additional inspectors. And the result of that would have been, we would have been able to put more focus into the casino as a consequence of having more resources.
Did you think that greater focus was needed?
As the landscape around casinos and the casino regulation, changing technologies, etc., changed, yes. When we were no longer operating in a 1985 environment.
So the situation as it was, with the level of resources in the inspectorate, if I can call it that, did you understand that that was driven primarily by cost savings and efficiency measures within the department?
Yes, by government generally.
Now, if we return to your job description, please, at gwc.002.002.0045 at page 0002, under section 5, heading Organisational Leadership and Management, do you see in the first bullet point under Organisational Leadership and Management?
Yes.
You have a responsibility for managing relevantly financial resources.
Yes.
To achieve divisional objectives and ensure that services are provided within relevantly budgetary constraints. See that?
Yes.
Now,
Yep.
You understood, didn't you, that the GWC was primarily and essentially funded through licence fees revenue,
Correct.
including a casino licence fee?
Yes.
Did you regard that licence fee revenue as a notional budgetary constraint upon the resources the department was to apply to the provision of services to GWC generally?
Yeah, that would be a fair statement.
Did you regard the casino licence fee revenue as a notional budgetary constraint upon the resources the department was to apply to the provision of casino regulation services specifically to GWC?
Yes, that would be fair.
Did the reverse position apply? Did you regard, and I'll explain what I mean by that, did you regard the GWC licence fee revenue as a budget that could only be applied to the provision of services to GWC?
Yes, but I'm not sure, other than for the function of the Director of Liquor Licensing, I'm not sure how you would separate out time in motion, I guess.
We'll come to that in a moment. Can I ask you this question first? Did you regard the casino licence fee revenue as a budget that could only be applied by the department to the provision of casino regulation services?
Yes, in support of the Gaming Wagering Commission. Yes, that would be a fair comment.
So coming back to the point I think you wanted to make just a second ago, was there any attempt within the department to recording and attributing budgetary allowances from the casino fee and the other licence fees that the GWC earned to GWC/casino regulation services?
No.
So can we take your example as a, take your position as Director of Licensing as an example? You've told us that you spent about 30% of your time on casino matters, but nowhere did you record that you spent 30% of your time on casino matters.
No. And that's an estimate.
I'm sorry?
That's an estimate.
And nobody from the financial area of the department, in terms of preparing financial accounts each year and so forth, ever asked you about the allocation of your time between liquor regulation, GWC regulation, or specifically casino regulation?
Not that I recall, no.
And the Deputy Directors licensing, did they ever record their time for budgetary purposes as to which regulatory area they were operating in, working in?
Not that I recall. In fact, I'd probably say nobody did. Perhaps the inspectors did, because they would have identified how many inspections of various activities in terms of gaming and wagering that they would have undertaken. But to the best of my knowledge, nobody in the department did.
How did you go about ascertaining that the money available for GWC services from the licence fee revenue was applied only to GWC services and not other department requirements?
Well, I guess because it's hard to separate that out, and we would have just taken the view that the department its sole purpose for existing is to support these two legislative frameworks. How you would separate them other than doing time in motion assessment, I don't know. So it would have just been a general position that was taken.
Well, I'm just trying to understand, if you've got licence fee revenue from the casino that is to be spent on casino regulation, that was your understanding, how did you ascertain that that's what was in fact happening?
Well, we were delivering services to the Gaming and Wagering Commission.
But to the value of the licence fee? For more than the licence fee or less than the licence fee?
I would probably say more than the licence fee. The department, I would have probably said more than the licence fee. The department had to acquire funds from consolidated revenue. It wasn't that we didn't run on only the Gaming and Wagering Commission income, to the best of my knowledge.
But it was providing a lot of services other than to the GWC.
It was providing services in support of the Director of Liquor Licensing, yes.
And we come back to the point, how did you then ascertain how much GWC was utilising in terms of the department's budget relative to the licence fee?
We didn't.
Do you know how the services to the GWC were costed, or were they just not costed at all?
I couldn't comment on that.
But you were responsible for management of the financial resources to ensure that they were provided within budgetary constraints.
For the division, which was the licensing division, yes.
But you'd need to know how much the services to GWC were costing within that responsibility, wouldn't you?
Yes, but again, I come back to, I have an officer who has 50 applications for casino employee licences and has 15 applications for approval of manager of a licensed venue applications. An application for a casino employee licence might take half an hour. The application for an approval of manager might take 2 hours. We did not have in place a system where those staff identified, okay, well, now I'm working on a casino application, now I'm working on a liquor. We didn't do it.
Why not?
Practicalities, effective use of resources.
Why is it impractical for someone to note in a timesheet the work that they're doing each day and how long it takes?
The department dealt with several thousand applications a year, in addition to the rest of the work that we were doing. I would argue that there's a better way of using staff time than having to record 10 minutes here, 10 minutes there. But that's just my view.
Can we come back to your witness statement, please, at paragraph 58, page 0013, where you say that in 2007 you and Mr Connolly considered that the department should be restructured.
Yes.
And you mention at 58 on the same page that part of the restructure you were contemplating included how the audit and inspection team could be better utilised.
Yes.
Now, that was a restructure that was in fact implemented, was it?
So we commenced, when both Mr. Connolly and I were appointed to our positions in 2007, we commenced this review of the department and how we did our business. That was a long process, and it was coming to its fruition when I left. We'd finished the recruitment of senior positions, as in director positions, and then there were, senior inspectors and so on and so forth down through the organisational chart thereafter. But we'd completed the selection of the senior positions in the department when I left. So
It was a work.
I assume it came to fruition.
All right. Now, where you say in 50, you include here that you looked at everything, including how the audit and inspection team could be better utilised. So was that something that had changed by the time you left, or was that still something to be considered and implemented?
I think it was organic. It was still being considered and implemented. During this same period of time, we had a change in government. We had some really significant, very controversial issues that we were dealing with. So, it's fair to say that the restructure of the department was one of the many things that we were taking on. So it was a slow process.
But just in terms of that process, what had been discussed and developed between you and Mr. Connolly in relation to better utilising the audit and inspection team?
So, in fact, there was the three of us. So there was the Director of Corporate Governance, Vanessa Grant, Mr. Connolly and myself. We looked at each of our team. We were responsible for the structure of each of our teams, obviously. So Ms. Grant looked at corporate services and what they were delivering. Was there a better way of doing that? I looked at licensing. Mr. Connolly looked at compliance. But clearly we talked about how that all worked together. Did I determine how Mr. Connolly's team would operate? No, I didn't. But certainly I was involved in discussions around what's the best use of those resources, what's our commitment here, where is the priority at the moment of the current government, what are we looking at? And we would have talked about how to use the compliance team based on all of that.
What I'm asking you is what was the content of those discussions?
What was the content?
Yes. What were you talking about in relation to better utilising the audit and inspection teams? What was being discussed?
What's the current risks that we have facing the agency at the moment? And one of them would have been we had in Western Australia on licensed premises, for example, concerns around the potential for organised crime. We had significant levels of antisocial alcohol-related violence occurring on licensed premises. And one of the things that the compliance team was looking at issues around, rather than a black brush, paintbrush approach to it, what were there specific premises that were of greater concern? And was it a premises-based issue or was it a social issue generally? Those were sorts of the discussions we were having, and whether or not, okay, we need to place greater focus on this particular premises or we have issues in relation to this precinct. For example, Northbridge was an area of concern. But it's fair to say the casino was not a premises that caused, and by premises I mean a complex that involved the hotels, bars, restaurants, and the casino footprint itself. It was not a premises that we were concerned about to the extent of harm like we were at other premises. So, yeah, it's probably fair that we were looking at, you know, where do we need to put the resources at the moment? What's the current issues that we need to be concerned about?
And that was orientated towards and focused upon more of the liquor licensing area rather than casino regulation.
It would have been in 2007 to 2010, yes, it would have been.
Now, can we take you back to paragraph 24, please, at 0007? You described that you and Mr. Connolly were developing a proactive and strategic regulatory plan.
Yep.
Is that something different from the restructure you refer to at 58, or is it the same thing?
Same thing, yeah.
And you refer at 24 here to the fact that it would require additional resources.
Yes.
Resource implications for the department.
Yes.
In what way?
Okay, so when the so one of the problems that we had within the agency was we had very antiquated and not particularly useful IT solutions. So, and this is just merely an example. So one of the things that we identified was that we needed a IT solution that covered racing, gaming and liquor that would allow us to not only have a licensing function within that IT solution, but also a compliance function, that a system that would allow us to record data and track and report better than the systems that we had. So one of the areas that we identified was we need additional funding in order to replace our entire IT solution for the agency. I think we also sought for an additional full-time equivalent, so an additional FTE. In fact, again, I don't have access to any documents to confirm my recollection, but I've got a recollection of us seeking additional funding for 2 full-time equivalent inspectors.
For the liquor area in particular?
No, for the department.
Now, I gather from what you say in paragraph 24 that you were by no means confident, indeed not even optimistic, that you were going to get those additional resources from government.
Yes.
Can I take you to...
But can I say, though, we did, in fact, get... I believe that we got funding for that IT solution that we wanted, and I recall getting funding for an additional FTE, but that's just my recollection.
Well, can I take you to some minutes of meeting of the GWC of the 28th of February 2012? That's gwc.0002016.0054. Now at page 0007. See under general business, the second paragraph.
Yep, sorry. Thank you.
So that's you, the Director of Licensing, I assume,
Mm-hmm.
providing members an overview of the Productivity Review Program.
Yep.
Is that the plan that you've described in 24 and 58 of your witness statement?
That would seem appropriate, yes.
Yeah. And you say it's anticipated the new structure will be in place by July 2012.
Yes.
So does one infer from that that the resources were forthcoming?
Well, sorry, the actual IT solution was well into its development by that point in time. I think we got the funding for the IT solution probably around 2009, but don't quote me on that. So the IT solution was well and truly on the path to being designed and tested by that point in time. The FTE, again, that would be, you'd have to check on that, but I assume that we got the funding for the FTE as well, and we filled those positions.
To your recollection, did the IT system have the capability of separately recording the costs of the time spent on different regulatory functions? For example, casino regulation.
Look, it could quite possibly have. It was a pretty cutting edge solution. It wasn't something you could buy off the shelf. We were getting it built specifically for the department. So it's quite possible. I couldn't confirm that though.
Commissioner, I tender those minutes, GWC.0002.0016.0054.
That document is admitted into evidence as an exhibit.
Thank you. Now, just changing topics, Ms. Belling, and finally I want to talk to you about conflicts of interest.
Yes.
Were you responsible within the department for developing or maintaining policies in respect of departmental officers declaring and managing conflicts of interest?
No, that would have been a corporate governance policy, which would have fallen under the Director of Corporate Governance's responsibility.
And so similarly, no responsibilities in relation to GWC policy in that regard?
No, but look, I don't recall whether or not the Gaming Wagering Commission had their own specific policy. I'm only assuming, but I suspect that their policy would have been the department's policy, but I can't confirm that.
During your tenure as Director of Licensing, did you become aware of any instances of departmental staff involved in casino regulation having personal relationships with Perth Casino employees?
There may have been an inspector who had a son or daughter who'd applied for a position at the casino, but none that I can specifically recall.
Did you have any concerns that may be occurring?
It wasn't something I thought about on a daily basis.
Did you think about it at all?
Yes and no. I mean, I don't know how to respond to that question. Yeah, I don't know how to respond to that. Of course you'd be concerned about it, but did I go and ask staff, do you have a potential conflict of interest? No, I didn't.
If someone had declared to you a personal relationship with a Perth Casino employee,
yes,
what would you have done about it?
Firstly, I would have recorded it. I would have recorded it, reported it, would have sat down and talked to the staff member and probably involved the Director of Corporate Governance, the Manager of HR. What are our options for dealing with this? Can we remove the employee from dealing with casino applications? Can we move them into a different area? I would have looked at what were the options for responding to that.
Were you aware of any instances of former department employees working for Perth Casino?
Former department. Mr. Michael Egan, but I didn't. Mr. Egan was long gone from the department before my time, but I know that Mr. Egan was working at the casino.
What about Mr. What about Mr. Paul Hume?
I became aware that Mr. Hume was working at the casino. I, again, never knew Mr. Hume when he was working at the department.
But did it raise any concerns for you in terms of conflicts of interest that he was working for Perth Casino?
No, because he didn't go directly from the department to the casino, to the best of my knowledge, but I had no concerns with Mr. Hume working at the casino, no.
You weren't concerned that he might be someone who the existing employees might favour in terms of making arrangements or regulating the casino because of past associations?
No.
In hindsight, do you think you should have had concerns?
No.
Were you aware of Mr. Connolly's friendship with Claude Murray of Perth Casino?
I was aware, a friendship, no. Mr. Murray and Mr. Connolly, in my observation, had a professional relationship of regulator and operator.
Were there any occasions when you were at the department upon which the department held work functions such as lunches, dinners, Christmas parties, that sort of thing at the Burswood Resort?
Not that I recall.
Thank you, Ms. Belling. I have no further questions.
Thank you. Ms Cale, Mr Dharmananda,
No, nothing arising, thank you.
Mr Evans.
Just briefly, if I could, thank you, Commissioners. Ms Belling, you gave some evidence earlier about engagement with AUSTRAC. The AUSTRAC regime was introduced, which I think we can take it would have been sometime after 2006. I don't know whether you can recall the date with any more precision.
No, I don't, sorry, no.
I take it that that was an occasion when AUSTRAC actually reached out to the department to engage, was it?
Yes, yeah, and again, I can't give you any specifics, but I do have a recollection of meeting with AUSTRAC representatives.
All right. In your time with the department, which would then have gone on for another 6 years or so, apart from your leave of absence, do you have any recollection of AUSTRAC reaching out again to the department?
Not to me directly. That's not to say they didn't, but not to me directly.
No, thank you. Following the conference which you attended, I think in 2011, where you came back and reported to the GWC in relation to issues that you had observed in the course of that conference.
Yes.
Some questions were put to you as to whether there might have been the initiation of a consideration of review of policies or procedures or legislation in relation to the issues which you'd identified. Is it the case that the policy resources to undertake those activities will be required to be provided by the department?
Yes, that would have been correct. Unless the government was of a mind to initiate a much more detailed and review of the entire legislation. But otherwise, yes, it would have been the department.
And finally, there were some questions in relation to, this is put to you principally in the question of your role as Director of Licensing, about the types of police certificate and police clearance which were obtained. Now, obviously, across the gamut of licensing matters for which you were responsible, there were a number of licensees and a number of different requirements for police approvals to be obtained from time to time. Is that right?
Yeah, that would be fair. Mm-hmm.
And you'd be familiar with, I think, probably 3 types of police clearance which could be obtained. The first would be a foreign national police certificate, that is a certificate from a foreign authority.
Mm-hmm.
And is that your recollection those were associated with junket operators in particular? Being foreign nationals?
Yeah, probably. I mean, I think any time that we had an application from somebody who was only recently new to Australia, we would ask them for a foreign national police report, but it probably would have been related primarily to junket operators, yes.
And there's also an Australian police clearance certificate, which I think is now the National Police Certificate.
Yes, correct.
And that lists effectively known offences which are disclosable, that is, convictions that are recorded.
Correct.
And then there's a third and more sensitive category in there, which is criminal intelligence information.
Yes, that's right.
And that's protected under the Casino Control, I think it's under the Gaming Wagering Commission Act under Section 20A. And that's a far more sensitive area of police inquiry, isn't it? Because it doesn't deal with convictions, it deals with actual intelligence from police.
That's correct, yes.
And the disclosure of that is required at Assistant Commissioner level and above, I think. Is that right?
I would guess that's correct, yes.
And you're not familiar with that sort of information having been provided to you in the course of your licensing activities, specifically in relation to junket operators?
No, I was not provided that specific in relation to junket operators, no.
Thank you. No further questions.
Thank you, Commissioner. Oh, sorry, Mr. Malone.
If I may, Commissioner, just one
Yes,
question.
Certainly.
Miss Belling, if we could bring up your witness statement at paragraph 87, which is underscore 0018.
87, you said?
Paragraph 87, yes, that's right. It starts with the words, in terms of conflicts,
Yes,
and you list there what you understand as guiding principles which demonstrate integrity.
yes.
My question to you in relation to that is, in your dealings with Mr. Connolly, was he someone who demonstrated integrity in the way that you set out in that paragraph?
Yes.
Thank you, Ms. Belling.
Thank
you,
Mr.
Commissioners.
Thank you, Mr. Malone. Commissioner Jenkins.
Thank you. Ms Belling, I am Commissioner Jenkins and I just have some questions arising out of your evidence. First, you said that the GWC had a focus on problem gambling across the casino floor.
Yes.
And I'm just wondering, how did the GWC determine the extent of problem gambling at the casino whilst you were involved in casino regulation?
So the Gaming and Wagering Commission had a committee, which was the Problem Gambling Support Services Committee. And that committee, if I recall its makeup, had like the problem gambling helpline people and support services type people on that committee who really were able to give advice to the Commission around the number of, for example, the number of calls to the helpline that they may or may not have received, and the nature of what those were about. So I would suggest, and it's my recollection only, that the Gaming and Wagering Commission relied on that on the Problem Gambling Support Services Committee in the main for guidance around what was happening.
So your understanding was that that was a committee of the GWC?
Yes.
And was your understanding that it reported to the GWC?
Yes. Yep.
And in terms of information it provided to the GWC, we would expect to see that information contained in the board packs for the GWC?
Sorry, I missed, you just dropped out at that last bit.
To the extent that it provided information to the GWC, we would expect to see that in the board packs for the GWC.
Yes, and in the minutes of meetings, yes.
And so what was your view whilst you were Director of Licensing as to the extent of the problem gambling associated with the Perth Casino?
My view. My view actually was that the Perth Casino was not contributing any more or less to the problem that we already had, I guess, in WA. We weren't seeing an increase in problem gambling that I recall. So we were keeping, a dreadful way of referring to it, but we were keeping a lid on it, I guess, if I can put it that way.
So it would have only been that if you thought that there was evidence of that it was increasing, that you thought that anything different would have needed to have been done.
Yeah, yes, but I guess we were always looking at what can we be doing better anyway. And if I can use an example, I recall the casino operator wanted to introduce a new electronic gaming machine. And so an application was put, proposal was put to the commission around that machine. And the commission members at that time weren't entirely comfortable with how that machine looked, behaved, etc. So the commission asked, the members asked for Mr. Connolly to arrange for a demonstration of that machine. So a demonstration model, for want of a better description, was brought into the commission's hearing so that they could see, well, what did it look like? And one of the areas, if I recall, that was of concern were the symbols that were displayed on the screen of that machine. And there was lots of discussion around just the mere nature of the symbols and what did those symbols, what were they appropriate? Were they a responsible symbol? You know, it's just those sorts of things. There was lots of discussion around, as simple as that, whether or not the game looked okay. And it might have been that the commission members might have said, well, we don't particularly like this treasure chest symbol. We would prefer for it to have a card symbol. You know, it could be something as simple as that. So it was a constant, it was always, I would argue, on the in the minds of the members.
Moving on to another topic, that was the issue of conflicts of interest. Did you know that Mr. Connolly had a friendship with someone called John Nichols who worked at the casino?
Yes, in fact, John Nichols had been at the department for a very long time, went from the department up to the Minister's office as a advisor in the Minister's office. And he was up there. In fact, I replaced...
I think you've gone beyond the question I asked you. You knew about the friendship.
Yes.
And as a result of that, was there any requirement of Mr. Connolly to make a formal declaration of interest?
Okay, so Mr. Nichols was not working at the casino when I left the department. I don't know when Mr. Nichols started working at the casino, but I would assume that the obligations on Mr. Connolly were the same as the obligations on anybody of the department to report their friendship with Mr. Nichols.
Turning then to his friendship with Mr. Murray, you say that whilst you worked at the department, you were unaware of their friendship outside of work.
That's correct.
So you do not recall any references by Mr. Connolly to having social activities on the weekends with Mr. Murray, for example?
No. In fact, I think Mr. Murray was relatively new to the casino when I was in the role. But no, I don't, Commissioner, no.
So that may have been, depending upon the timeline, that may have been because he wasn't having social events with him. But can you just tell me, in relation to your conduct with Mr. Connolly, was it usual for you, say, to discuss with Mr. Connolly what he'd been doing on the weekend, what you were doing on the weekend, that kind of thing? Was that the level of conversation you had with Mr. Connolly?
Yes.
Yeah.
We were close colleagues, worked together in the department for a very long time.
Thank you. Now, this is hypothetical, so I don't want anyone to think that I'm putting to you a situation. But if, for example, someone within the department who was working in casino regulation, at the time you were Chief Casino Officer, if they had, and you heard about a possible conflict of interest or actual conflict of interest with due to a relationship with someone at the casino, would you have, as Chief Casino Officer, regarded it as your obligation to disclose that to the GWC?
Yes.
And did that situation ever arise whilst you were CCO?
No.
Moving on then to your role as the Chief Casino Officer. When you attended GWC meetings as the CCO, did you feel that there was any conflict between your obligation to provide independent advice to the GWC as the CCO and your role as a departmental officer?
No, I did not.
Now, as departmental officer, you would have known that there were departmental requirements, say in relation to to stick within budget, that kind of thing, which didn't apply, say, to GWC. GWC wasn't bound by departmental requirements about budget, were they?
No.
So when you had an issue which related to financing or would cost some money, a program for the GWC, did you feel free to recommend to the GWC programs that might take it beyond the capacity of the department to finance?
Yes, I did feel free to do that. I never felt constrained in my communications with the Commission.
Now, a couple of matters that you weren't examined about, and the first is in relation to the casino granting credit to gamblers. Direction 3 capital F of the casino directions
Yes.
permits the casino operator to provide credit to international commission business players. And it says that that was inserted in the directions in 2005. Do you know anything about the insertion of that direction?
No, I do not.
And when you were the Director of Licensing and the CCO, did you have an understanding of the circumstances in which the casino could provide a line of credit to gamblers?
No.
So during that time, do you recall whether you looked at the extent of the credit being provided to overseas gamblers?
No, I don't recall. I'm sorry.
Do you recall looking at the extent of bad debts arising out of the provision of credit to gamblers?
No, I don't. I'm sorry.
Do you recall looking at who was being granted credit and why?
No.
Did you consider, well, so if you didn't look at those things, can I take it that neither did you consider how bad debts would be recovered from overseas players?
No, I did not.
Then finally, in relation to your role as the CCO, the Casino Control Act gives the CCO the power to initiate prosecutions. You're aware of that?
Mm-hmm.
And you were aware that a breach of the directions by a casino licensee is an offence under the Casino Control Act?
Yes.
And those directions include a requirement that the casino licensee operate the casino according to the casino manual provisions.
Correct.
So what did you think your role was as CCO in ensuring that the directions were complied with?
My role? In a practical sense, my role was working in collaboration with Mr. Connolly and his team. They would conduct the audits and inspections, random audits and inspections of compliance with the operations manual, and I took my from there, I communicated with the Gaming and Wagering Commission. So, yeah.
As the Chief Casino Officer, did you ever initiate a prosecution against the casino licensee?
No, I did not.
Did you ever recommend to the GWC that such a prosecution be taken?
I don't recall doing so.
The casino manual, as I understand it, and requires the casino operator to have an anti-money laundering program, which confirmed with the relevant AUSTRAC legislation. Do you know if this requirement was audited whilst you were Director of Licensing or CCO?
No, not to the best of my recollection.
Thank you, Ms Belling. I don't have any other questions.
Thank you.
Yes, Ms Belling, just in terms of those audits and inspections, can you tell me your understanding of how they were developed? Were they developed internally within the department or?
Yeah, they would have been developed within the department and over a long period of time, and would have been developed by the inspector compliance team.
And a risk-based approach, was it? Or can you tell me anything about the approach they took to developing those?
No, I couldn't, not with confidence, but yeah, I'm going to go with the risk-based approach, but I couldn't do that with confidence.
Okay, thank you.
Ms. Belling, I've just got a couple of questions for you. When you were shown the job description form and the corporate chart,
Yes.
there was a position, Deputy Director Licensing - Policy.
Yes.
And I think you said that one of the functions of that person was to look after legislation.
Yes.
Can I ask you this? If there were to be some legislative instrument, a statutory instrument, what was the process? If, say, the Gaming and Wagering Commission would make a decision that a regulation was needed, what was the process by which that decision of the Gaming and Wagering Commission went from the Commission into, if you like, the parliamentary process to be put into effect?
Okay, so the decision would have been recorded in the Gaming and Wagering Commission minutes meeting. That would have formed the formal basis for that process to commence, but the reality or the practical would have been immediately that I left that meeting, I would have sat down with Mr. Beecroft and said, okay, this is the position that the Commission has taken. The minutes will confirm that position. We need to get the ball rolling. So Mark and his team would start drafting whatever that proposed instruction to Parliamentary Council would be. And then Mark and his team would work with Parliamentary Council on the drafting of that. It would come back to the department as a draft, and that would be presented to the Gaming and Wagering Commission, and probably in a practical sense to the chairman of the Gaming and Wagering Commission.
Right, so I think I can stop you there. So the primary departmental officer would have been this person called the Director Licensing Policy.
Correct, yes.
And if we're looking at around early 2010, that would have been Mr. Beecroft, I think you said?
I believe so. I mean, Mark was traditionally in that role, but...
All right, that's fine, thank you. Now, you gave evidence that it was your practice when you exercised the delegated power as Chief Casino Officer, you would report that to the monthly meetings of the Commission. Mm-hmm. But you said when you exercised delegated power for licensing. Do you remember saying that?
Mm-hmm.
For licensing?
Yep.
Can you just explain to me what you meant there by for licensing?
In relation to licensing functions, so the approval of casino employee licenses, for example, approval of lotteries, raffles, those sorts of things, the licensing function.
So if there were an exercise of delegated power that was not a licensing matter, and I'll give you an example, an amendment to the Casino Operating Manual,
Oh, yes, yeah.
would you have included that in?
Yes.
your report?
Yeah, that would have been a different agenda item, but yes.
All right, thank you. Now, can I come to the junket approval process? This is just to clarify for me. You said that it was, so far as your involvement was concerned, it was a two-stage process. First of all, there was the gathering of information, which was a part of the licensing division's function, and then the consideration of the material, the interview process, and the formal consideration of the process, which was within the compliance division. Mm-hmm. But then you said that at least at some point, the formulation of the paper that went to the Commission, including the recommendation, was done by licensing. And I just want you to explain to me why that would happen if the actual consideration of the merits of the application had been done by another division, namely the compliance division.
I would probably suggest it was a collaborative approach because the application was a licensing responsibility in as much as the receipting, processing and finalisation of that application fell within the licensing area's responsibility. But we worked with the compliance team and the inspectors in assessing that application. So the recommendation or the agenda paper, it would have just been from a practical perspective, I guess. I can't give you any more of an explanation than that, I'm sorry.
All right. Now, can I then turn to another topic, which is the relationship between the Chief Casino Officer and the Gaming and Wagering Commission?
Yes.
Now, the evidence seems to suggest that the Gaming and Wagering Commission didn't have any employees.
Correct.
Could I ask you this? In your role as Chief Casino Officer, and this is non-technical, it's resorting to the vernacular, but did you see yourself as the Chief Casino Officer as effectively the CEO of the Commission?
No, I did not.
Well, what did you see as the relationship between your functions and your role as the Chief Casino Officer and the Commission?
I saw myself as the senior officer working for the Commission. I saw the chairperson of the Commission as the CEO, if you want, if you would like that sort of description. But yeah, I saw myself as the senior officer.
All right, thank you. Now, my last question comes to money laundering, and you gave evidence that in your either during or as a result of your discussions with the representatives of Austrac soon after or around the time of the introduction of the Commonwealth legislation, that you saw it to be the role of Austrac to identify, investigate and disrupt criminal interference with Australia's financial system. Can I take it that you would have regarded that role as being applicable to that sort of activity that occurred within the casino?
Yes, right. The Austrac function.
And is it fair to say then that if you took the view that the identification, investigation and disruption of criminal activity in the form of money laundering within the casino was not really the concern of the Gaming and Wagering Commission or the department because Austrac had the primary responsibility for that? Is it fair to say that that was a view that you took?
The Gaming Wagering Commission was certainly concerned about it, but in terms of the agency Yes, I would say AUSTRAC had the greater responsibility.
All right. Now, when you were asked, and I think this was in relation to the structural review that you conducted with Mr. Connolly that's referred to in paragraph 58 of your witness statements, I think that's where it was, there's no need to bring that up. But you said that there was a lot happening at the time, there was a change of government and things were moving. But one of the concerns that you had was about organised crime within licensed premises, which I took to mean liquor licensed premises.
Mm-hmm.
Would you not expect the police to have a critical role in the identification, investigation and disruption of criminal activity in liquor licensed premises?
Absolutely. And we had a fantastic relationship in that respect with the WA Police.
So then what was the difference between that sort of role, that sort of concern for the department and the Gaming and Wagering Commission in relation to licensed premises and that same concern in relation to the casino?
There wasn't a difference. I think where the difference rests is in I guess there's two components to it. There's the financial system and the investigation and detection of criminal activity in relation to the finance system. And then there is the detection and investigation of criminal activity in a physical sense. So, for example, when we were looking at suitable persons and whether or not people were fit and proper to hold licences, be they casino employee licences or a manager at a licensed premise, a liquor licensed premises. What we were really looking at in that respect was to ensure that those people didn't have links to organised crime that we were aware of. And it was in that respect that we worked very closely with WA Police. The WA Police would not have been looking at the financials in the way that AUSTRAC would have been. I think they probably, and I could be wrong, I think their area of focus was two different aspects of criminal activity.
All right, thank you. Ms. Cale, anything arising from that? Ms. Seaward.
Thank you. Just a few questions. Ms. Belling, you were asked a series of questions about the licence fees.
Yes.
The casino licence fee. In your role, did you have any role to play in preparing the budgets for the Commission or the department?
No. As a general rule, the budgets were prepared by the Chief Finance Officer of the agency.
And did you have any role then in the bank accounts of the Commission or the department?
No.
You were asked a series of questions about the risks and the broad risks that that the department was looking at the time and the Commission.
Mm-hmm.
And we don't need to go to, but referred to paragraph 39 of your statement. In terms of the broad risks that the department or the Commission, you can identify which, were considering in the space of matters that related to the Gaming and Wagering Commission, during your time, what were those key risks that had been identified?
Well, I spoke about online gambling. That was an area of concern. Juveniles. That was always an area of concern. I can't be more specific, really.
How were those risks identified? What was sort of the process that went through to identify them?
So with the juveniles, let's take the juveniles. That's a really good example, actually. The casino was required to report to the Gaming and Wagering, or provide to the compliance area, I should say, and they provided the report for the Gaming and Wagering Commission on the number of juveniles that had been identified each month on the casino, on the property and on the footprint. At one point, the Gaming and Wagering Commission had a concern that we seemed to have an unusual number of juveniles. And what was happening? Why was that happening? How is that being addressed? How's that being rectified? Was the focus of the Commission. And each month we would look at that. For quite a while, that was an area of attention.
And in terms of the online gaming that you referred to, how was that risk brought to everybody's attention?
So I think I mentioned earlier, it's not something that we suddenly came upon. I guess it was a conversation that was occurring across Australian jurisdictions and certainly influenced by conversations on an international scale, that things are moving, that technologies are moving rapidly. Is our legislation responsive? So I recall discussing it at commission meetings a couple of times actually, and it was usually as a consequence of, it might have been as a consequence of discussions we might have had with another jurisdiction or that came out of conferences, etc. But meetings generally between regulators of, hey, we need to be concerned about this. You might not have seen that in Western Australia yet, but this is what we're seeing on the eastern seaboard.
So to the extent you were in the department at least, was advised of any matters at these Australian interjurisdictional meetings, to the extent any of them identified risks, what steps did you then take to let the Commission know?
I would report to the Commission at the Gaming and Wagering Commission meetings.
No further questions, thank you.
Thank you. Ms. Belling, thank you very much for your evidence. It has assisted us, and I can now formally release you from your obligations under the witness summons. Thank you very much. And
Thank you.
we will adjourn until 2 p.m.
All rise.